Welcome back to the virtual orientation for the English JD program. In this podcast, I speak to Professor Pierre Fouché about the civil law tradition of the province of Quebec and how it's distinct relative to the common law tradition in which you're schooled in the JD program. Many of the people with whom you share the building at the University of Ottawa's law school are being schooled in the civil law tradition. And an understanding of the law of the province that lies just across the river from Ottawa is a useful aptitude for any common law lawyer. It is important to understand the terminology, though. Civil law, in the context of this conversation with Professor Fouché, refers to the civil law tradition of the province of Quebec, inherited from the French tradition. The term civil law also arises in the common law tradition with reference to those private law issues such as tort, contract, and property that give rise to a civil cause of action or a civil action. Civil law in this matter is different from criminal law. And so do not confuse the varying meanings of the word civil as we progress. Again, the focus in this conversation is on the species of law inherited in Quebec from the French tradition known as civil law. I began by asking Professor Fouché to introduce himself.
My name is Pierre Fouché. I teach here at the Faculty of Law, University of Ottawa, both in the civil law and common law sections. I teach mainly Introduction to Public Law, Division of Powers, Federalism, and also language rights.
And so your original learning in law would have been in the civil law tradition?
Yes. My first background was in civil law. I graduated from University of Montreal.
And so what is civil law?
Civil law is a system important from France, mainly. And the main topic or the main issue about civil law is the pretension to have all the law within one code. So civil law students and civil lawyers will mainly use a civil code to look into legal answers to any problem that is put to them.
And so how does that differ from the common law?
Well, it is. There are many differences. I think the common law is mainly a judge-made law. Not to say that there are not legislation and statutes passed by Parliament, but the judges have a much more important role to play in common law. In civil law, and it dates back to Napoleon and even earlier than that, some civil law thinkers would say that the judge in a civil law system is only the mouth of the law. He has no role whatsoever into creating a rule. All he has to do is to interpret a rule that he finds in the code.
And so which jurisdictions in Canada use civil law?
Only Quebec and only in the private law matters.
Some of the students will very quickly be learning in their common law studies, they will be taking topics that we describe as civil as opposed to criminal. Should they confuse our reference to civil topics in that context with what you mean by civil law?
No, civil law relates to private law matters. For instance, in the Civil Code of Quebec, you will find dispositions and sections about contracts, about torts, about obligations, about family law matters, about the responsibilities between parents and children, and things like wills and estate, all matters pertaining to the private law of the citizen.
And so that's all codified in a civil code?
Indeed. So I will take a very easy example, even for people who haven't really studied in depth. In common law, torts are defined by the courts. They are specific to, there is different criteria for different torts, okay? In civil law, you have only one section in the code saying a tort is a fault, an error or fault, and then damages, and then a causal link between the two. If you have those three elements, you have a tort. That's it, that's all. So all the judge has to say is to look into the situation, say, is there a fault? Is there damages? Is there a causal link between the two? Yes, then there is a tort.
So that suggests that students in civil law will read fewer cases.
Indeed, actually, I remember some classes where there were no cases whatsoever involved, and we did only read the code and interpret the code. The role of doctrine is much more important. Commentators will write treatises about dispositions of the civil code, and that will weigh very heavily when the matters come to court. The judgments in Quebec, for instance, in the civil law section, are much more formal. They use the French way of writing, attendu, attendu, considérant, considérant, and then the issue, what in common law we would call the ratio of the judgment, the core of the decision, to them will be just one paragraph. It is very succinct, very reasoned, very logical, and facts are not as important as the interpretation of the law.
And so is there a difference in the way that common law and civil lawyers think?
Oh yes, definitely. Civil lawyers will tend to look into the principle. They will tend to go from the more general to the more particular. Whereas common lawyers work the other way around. They will tend to start by the facts and then try to interpret the facts to see what kind of laws could be applicable to the facts.
And you move in both worlds.
Yes.
Is it difficult to move back and forth?
Yes, it is indeed. When I teach in the common law section, well, naturally, I have done all my career in common law faculties, so I've been exposed to a lot of common law, and I've learned from my colleagues how reasoning goes and how to deal with matters. But in common law, you give a lot of cases to read to the students. And then you skim through the cases, trying to find the rules, trying to find the thread between the cases to see what's the rule and how to distinguish cases from one another. When I do that in civil law, the students are confused, especially in public law matters, because in public law, it is the same law everywhere. The Constitution is the same throughout Canada. The criminal law is the same throughout Canada. Administrative law, public administration is the same throughout Canada. So they have to be exposed to the common law somehow, but they are very wary and confused about that because they will, in their other classes, all they do is read the civil code and discuss the sections. And when they ask me, where is the answer to such and such problem, I say, not in the code. There is no codes here. Okay? If you will not find the answers in the cases, but you will find some arguments in the cases. So read your cases carefully and try to find in the cases what is important for the next issue that will arise to you. So yes, there is a lot of difference. There would be also, if I might say so, a difference in the way to apply and interpret the Constitution. Common lawyers in the British tradition are more pragmatic. We'll fix the problem when we have a problem. Whereas in the civil law, they tend to like to have everything written down. Let us take again a simple example, the spending power. Federal government spends money in education. Now, education is a provincial jurisdiction, but it is recognized or implicitly accepted that the federal government has the power, the constitutional power, to spend money into areas belonging to the provinces. Now, if you look around, which province is opposing that most fiercely? It is Quebec. Now, of course, there is a nationalist question, but beyond that, I think there is a cultural problem here, or a cultural issue, because civil lawyers don't like implicit things. They would like the spending power to be written down in the Constitution with firm rules that you will refer to in order to be able, first of all, to identify the power and then how to exercise it. So this is only one difference among many others between the two systems.
So just so our listeners are clear, in the province of Quebec, the private law matters, torts, contracts, property, codified into a civil code.
Yes.
And then in areas of criminal law and public law, which would include administrative and constitutional law, those are national areas, and so it sounds like it's a bit hybridized in the sense that there is a criminal code, and so you have law that's written down, literally called a code, but the way that it's construed, because it's meant to be national, there's a construal that draws on the common law tradition of the other provinces.
Indeed.
And so a lawyer in Quebec can confine their discussion and their analysis to the civil code for purposes of private law, but as soon as they move into the realm of public law and the criminal law and the like, they have to be attentive both to the criminal code, but also then the common law way of learning.
Indeed, and they have to be wary of the common law way of reasoning and the common law way of applying the Charter of Rights, for example. The proportion of private law, let us say that, rather than public law, I don't know, but in civil law faculties would be maybe 70% private law and 30% public law. So, like it or not, the students are much more exposed to the civil law way of thinking. And when they get into common law matters or national matters, they tend to apply these reasonings to the public law matter, first of all. Secondly, their schemes of reference in law are in France. Now, in France, the way they construe and they interpret the law itself is very different from Great Britain. For example, we have a Supreme Court. In France, you don't have any Supreme Court. You have 3 different levels of courts for specialized matters. They have the Conseil d'État for the administrative law. They have the Conseil constitutionnel for the constitutional law. And they will have la Cour de cassation for private law matters. Whereas we have only one Supreme Court for the whole of the law. And so you see that they have a way of specializing and entrenching the law in different areas with very fixed differences between themselves. Whereas the common law, the word says it's common law, it's the law, the loi commune. It's the common law of everybody. And if you retrace the origins of the common law, it was the king that was trying to impose his own law upon everybody, including himself. At one point in history, in the history of Britain, the king was also subject to the laws of the land. And there was no exception for the king. So it's the common law of everybody. And there is no specialized jurisdiction. So this makes for a challenge, I would say, for civil law students to gather into public law.
And what about going the other way? What about for the common law students who are taking common law right now and contemplating practice in provinces outside of Quebec? To what extent is the civil tradition important to them?
Well, the civil tradition is very, very heavy in international law, in international forums, because naturally you have very important countries using civil law and that are part of international treaties, part of international organizations. So the civil law tradition is very much present in international law matters. In private law matters outside of Quebec, if you're not in a border area or you don't have a case dealing with somebody residing in Quebec, you will probably not get exposed very much to the civil law matter. But anytime you will have a client or a company or somebody having links with Quebec, you will have to be able to understand that it comes from a different legal system, and that in private law matters, the civil law is very much different from the common law. That is the way of thinking. I'm not talking about the end result, the law itself, the rule itself, but I'm talking of the way of thinking. Maybe I should mention another way that civil law influences the practice of law outside is in federal matters. Because in federal matters, they have to take into account the fact that part of the federal legislation will apply in Quebec. And let us say, for instance, federal real property in Quebec, in Gatineau, for instance. You have federal buildings, okay? But they are, so under federal law, but they are into a civil law jurisdiction. So the legislation must take that into account. So we will have sometimes in federal legislation some sections saying, well, in Quebec, the rule is such and such because it is different, because you have to take into account the civil code.
Now, there's a term that is often used in this law school and in this town called bijuralism. What do we mean by bijuralism?
Well, it's about the example I just mentioned. It is that in some matters, some areas of the law, you have to take into account both systems and you have to accommodate both systems. And actually, you have to be even, it is even more complex than that because you have the common law in French and you have the civil law in English. So you have the legal system that you have to take into account, and you also have the language you have to take into account.
So it's not just bijurism, but also for both systems you have to be concerned about bilingualism.
Indeed. And you have to be careful because the same word might not mean the same thing in a civil law system and a common law system. So you have to be, and there are people very specialized. Actually, it is a branch of the law that is quite specialized, and if students want to get into that, I know that there is a lot of demand for those people that have a background both in civil law, common law, and also language matters. It is called jury linguistics, and it is highly specialized. Very few people in Canada are specialized in jury linguistics, so they are sought after because they are the experts choosing the exact terms for any jurisdiction in any language.
Because, of course, so many provinces in the federal government have bilingual statutes, and so the words that you use in those bilingual statutes are equally important, one versus the other.
Yeah, that's right.
Anything else that you'd like to convey to our listeners about the civil law tradition and bijurism?
Just to be mindful when you deal with colleagues from Quebec or civil law, even in the law school, colleagues coming in from the civil law section, that they have been exposed to a system where everything is codified. The answers to the exams are in 5 lines. You would identify the correct section of the code to apply, and you say why it is applicable. So you have to be mindful that these people come from that background, and to them it is an adaptation to get into the system of the common law. I suppose the reverse is true also. A common lawyer that will come to the civil law system for another year will be quite surprised that he or she will not have any jurisprudence to read, not many cases, but a lot of legislation, a lot of code, and a lot of doctrine.
Wonderful. Thank you very much, Pierre.
You're welcome.